Question 1. A notary public is asked to notarize a document that contains blank spaces. The notary should A. Fill in the blanks with "not applicable" and then proceed with the notarization. B. Refuse to notarize the document until the signer fills in the blank spaces. C. Advise the signer on what information should be placed in the blanks. D. Complete the notarization but make a note in the journal that the document had blanks. Answer: B. Refuse to notarize the document until the signer fills in the blank spaces. A notary must refuse to notarize an incomplete document because it presents a high risk for fraud, as information could be added later without the signer's consent. The notary's role is to verify identity and witness the signing of a complete instrument, not to process a document with missing information. For instance, if a loan agreement has the loan amount left blank, a notary must insist the signer fills it in before the notarization can proceed. Remember this simple rule: if there are gaps, the process stops, as notarizing an incomplete document is a serious violation of notary law. Question 2. A notary public's commission is valid for a term of A. 2 years. B. 4 years. C. 5 years. D. 6 years. Answer: B. 4 years. In California, a notary public commission is issued for a 4-year term, beginning on the date the commission is issued and ending 4 years later. It is the notary's responsibility to track this timeline and apply for reappointment before the commission expires to avoid any lapse in their ability to perform notarial acts. Think of it like a vehicle registration or a driver's license that requires periodic renewal to remain valid. A good tip is to set a calendar reminder at least 6 months before your commission's expiration date to start the renewal process. Question 3. When a notary changes their business or residence address, they must notify the Secretary of State within A. 10 days. B. 14 days. C. 30 days. D. 60 days. Answer: C. 30 days. A notary public is legally required to inform the Secretary of State of any change to their business or residential address within 30 calendar days of the move. This ensures the Secretary of State has current contact information for official correspondence and maintains the integrity of the public record. Failing to meet this 30-day deadline is a violation of notary law and can result in fines. To stay compliant, make updating your notary commission address a priority on your moving checklist, right alongside changing your address with the post office and DMV. Question 4. For which of the following documents is a notary public required to obtain a journal thumbprint from the signer? A. Advance Health Care Directive. B. Power of Attorney. C. Deed of Trust. D. Acknowledgement on a personal letter. Answer: C. Deed of Trust. California law specifically requires a notary to obtain the signer's right thumbprint in the journal for any document affecting real property, such as a deed of trust, quitclaim deed, or grant deed. A deed of trust is a document that secures a loan on a piece of real estate, making it a high-stakes transaction where extra identity verification is crucial to prevent fraud. While a thumbprint is good practice for all notarizations, it is only legally mandatory for these real property-related documents. Think property equals print to easily recall this important requirement. Question 5. The venue portion of a notarial certificate, such as State of California, County of _________________, indicates A. Where the signer resides. B. Where the document will be filed. C. Where the property involved is located. D. Where the notarization took place. Answer: D. Where the notarization took place. The venue establishes the geographical location where the notary and the signer were physically present at the time of the notarization. This is a critical component of the notarial certificate because it confirms the notary was acting within their jurisdiction. For example, if a notarization occurs in Los Angeles, the venue must state, County of Los Angeles, even if the signer lives in San Diego or the document pertains to property in another state. Always remember to fill in the venue with the county where you are performing the act, not where the signer is from. Question 6. If a signer's identification card is expired, a California notary may accept it as proof of identity only if A. The signer also provides a valid credit card with a photo. B. The expiration date is less than 1 year ago. C. It was issued within the last 5 years. D. The signer takes an oath confirming their identity. Answer: C. It was issued within the last 5 years. According to California law, an expired identification document is acceptable only if it was issued within the last 5 years. This provision acknowledges that people may not immediately renew their IDs but still provides a recent enough photo and description for reliable identification. The key clue here is the specific time frame. The law provides a clear 5-year window for these specific documents, such as a driver's license or state ID card. A helpful way to think about it is that while the ID is expired, the identity it represents has not, as long as the photo is reasonably current. Question 7. A subscribing witness is a person who A. Watches another person sign a document and then signs as a witness on the document itself. B. Appears before a notary on behalf of the principal signer to prove the principal's signature. C. Is named in the document and receives a financial benefit from it. D. Certifies a copy of a power of attorney. Answer: B. Appears before a notary on behalf of the principal signer to prove the principal's signature. A proof of execution by a subscribing witness is used when the main signer, the principal, cannot personally appear before the notary. The subscribing witness, who either saw the principal sign the document or heard them acknowledge their signature, appears before the notary under oath to vouch for the principal's signature. This allows the document to be notarized even without the principal present. For this to be valid, the subscribing witness must be identified by a credible witness known personally by the notary, not by an ID card. Question 8. The primary purpose of a California notary's $15,000 surety bond is to A. Protect the notary from financial liability in a lawsuit. B. Provide a fund for the public to recover damages caused by the notary's misconduct. C. Pay for the notary's state filing fees and education costs. D. Act as an insurance policy for the notary's employer. Answer: B. Provide a fund for the public to recover damages caused by the notary's misconduct. The required $15,000 surety bond is a financial guarantee for the protection of the public, not the notary. If a notary's error or intentional misconduct results in financial harm to a member of the public, that person can make a claim against the bond to recover their losses. For example, if a notary's negligence on a real estate document leads to a fraudulent transaction, the victim could seek reimbursement from the bond. A great way to remember this is that the bond is for the public's benefit, while a separate errors and omissions, (E&O) insurance policy, which is optional, is what protects the notary themselves from liability. Question 9. A notary who is also a licensed attorney is asked by a client to draft a power of attorney. In this situation, the notary A. May draft the document and then notarize the client's signature. B. May draft the document but must have another notary notarize the signature. C. May not draft the document because it is a conflict of interest. D. May only draft the document if they do not charge a fee for the notarial act. Answer: B. May draft the document but must have another notary notarize the signature. A notary public cannot notarize a document in which they have a direct financial or beneficial interest, and a notary cannot be a party to the instrument they are notarizing. While the individual's status as an attorney allows them to legally draft the document, their role as the drafter creates a conflict of interest for the notarization. Therefore, they can provide the legal service of drafting the document but must have a different, impartial notary perform the subsequent notarial act. This separation of duties preserves the integrity and impartiality required of the notary public. Question 10. A notary public's official seal must be A. Kept in a shared, accessible office location for convenience. B. Photographically reproducible and contain the state seal. C. Destroyed upon the expiration of the notary's commission. D. Used on all documents presented by a client, even those not requiring notarization. Answer: B. Photographically reproducible and contain the state seal. The official seal of a California notary must include specific elements, such as the notary's name, commission number, commission expiration date, and the California state seal, and it must produce a clear impression that can be easily photocopied. This requirement ensures that any copies of the notarized document will clearly show the notarial seal, preserving the document's authenticity. The seal must also be kept in a locked and secured area under the notary's direct control, and it must be destroyed upon resignation or death, not expiration, as the notary might be reappointed. Question 11. Which of the following actions constitutes the unlawful practice of law by a non-attorney notary? A. Charging the maximum fee of $15 for an acknowledgement. B. Advising a signer on which type of notarial certificate their document needs. C. Refusing to notarize a document with blank spaces. D. Requiring a signer to present a valid, state-issued identification card. Answer: B. Advising a signer on which type of notarial certificate their document needs. A notary who is not an attorney is strictly prohibited from giving legal advice, and this includes telling a signer whether they need an acknowledgement or a jurat. Choosing the correct notarial act has legal implications, and guiding a signer in this choice crosses the line from a ministerial duty to the unauthorized practice of law. The signer or the receiving agency must be the one to decide which certificate is appropriate. As a notary, if a signer asks for your advice on this, you must decline and state that you are legally forbidden from making that determination. Question 12. If a principal uses a signature by mark, such as an X, the notary must ensure A. The mark is witnessed by one credible witness. B. The mark is witnessed by two persons, one of whom must write the principal's name next to the mark. C. The signer provides a thumbprint in the journal, regardless of the document type. D. A physician's note is attached confirming the signer is unable to write. Answer: B. The mark is witnessed by two persons, one of whom must write the principal's name next to the mark. When a signer is physically unable to sign their name and instead uses a mark, California law requires a specific procedure to ensure the validity of that mark. Two witnesses must be present to observe the signer making the mark. One of these witnesses must then write the signer's name next to the mark, and the other witness must write their own name on the document as a witness. The notary then records the names and addresses of both witnesses in their journal entry. This two-witness rule provides a strong safeguard against fraud for a vulnerable signer. Question 13. A notary is asked to certify a copy of a birth certificate. The notary should A. Certify the copy after making it themselves. B. Certify the copy if the signer takes an oath that it is a true copy. C. Refuse to certify the copy. D. Refer the signer to the county clerk's office for a certified copy. Answer: C. Refuse to certify the copy. California notaries are prohibited from certifying copies of vital records such as birth, death, or marriage certificates because these are publicly recordable documents. The official custodian of these records, typically the county recorder or state-level Department of Health, is the only entity authorized to issue a legally recognized, certified copy. A notary should refuse the request and may inform the client that they need to obtain the certified copy directly from the appropriate government agency. The only documents a California notary can certify a copy of are a power of attorney or, upon request, entries from their own notary journal. Question 14. An acknowledgement certificate verifies that the signer A. Swore under oath that the contents of the document are true. B. Personally appeared before the notary and acknowledged signing the document. C. is a citizen of the United States. D. Understands the legal consequences of the document. Answer: B. Personally appeared before the notary and acknowledged signing the document. The core purpose of an acknowledgement is for the notary to certify that the signer personally appeared on a specific date, was properly identified, and acknowledged that they signed the document freely. Unlike a jurat, an acknowledgement does not involve the signer swearing to the truthfulness of the document's contents. The key word is acknowledged, which simply means the signer is formally admitting that the signature on the document is their own. Think of it as the signer saying, "Yes, that's my signature, and I signed it." Question 15. A notary public sequential journal must be kept in A. A public place for easy access by clients. B. The office of the notary's employer. C. A locked and secured area under the direct and exclusive control of the notary. D. The county clerk's office. Answer: C. A locked and secured area under the direct and exclusive control of the notary. A notary's journal contains sensitive personal information about signers, so protecting it is a top priority. The law requires the journal to be stored in a locked and secured area, such as a locked desk drawer or a safe, where only the notary can access it. This direct and exclusive control mandate means that even if the notary works for a company, the employer cannot have access to the journal. This rule is crucial for protecting signer privacy and preventing unauthorized access to the notarial records. Question 16. If a notary public willingly and knowingly commits an act of misconduct, they may be held liable for A. A maximum fine of $750. B. A civil penalty of up to $1,500. C. Damages in a civil action and a fine of up to $10,000. D. Revocation of their commission with no other penalties. Answer: C. Damages in a civil action and a fine of up to $10,000. Willful misconduct by a notary is treated very seriously under California law because it can cause significant harm. A notary who intentionally violates the law is not only subject to paying for any damages they cause to a person, proximate damages, in a civil lawsuit but may also face a separate civil penalty of up to $10,000 imposed by the Secretary of State. This severe penalty underscores the importance of a notary's duty to act impartially and ethically. Forgetting a minor step is one thing, but intentionally notarizing a fraudulent document carries heavy consequences. Question 17. A notary public may not notarize a document for A. Their sibling, if the notary has no financial interest in the document. B. Their own signature. C. Their employer. D. A person who does not speak English, if communication is established through a translator. Answer: B. Their own signature. A notary public is strictly prohibited from notarizing their own signature or any document to which they are a party or in which they have a direct financial or beneficial interest. The fundamental role of a notary is to be an impartial, third-party witness, and you cannot be impartial when notarizing for yourself. For example, if a notary creates a promissory note naming themselves as the lender, they cannot also notarize the borrower's signature on that same note due to their direct financial interest. A good tip to remember is, a notary can never be a signer on the same document they are notarizing. Question 18. If a notary resigns their commission, is not reappointed, or dies, the notary's journal must be delivered to A. The Secretary of State's office. B. The county clerk of the county where the notary's oath is on file. C. Any other commissioned notary public. D. The notary's personal representative or employer, who must then destroy it. Answer: B. The county clerk of the county where the notary's oath is on file. The notary journal is a public record that must be preserved even after the notary's commission ends. Within 30 days of resignation or non-reappointment, or upon the notary's death, the journal must be surrendered to the clerk of the county where the notary filed their oath and bond. This ensures that the record of notarial acts remains accessible for public inspection or for use as evidence in legal proceedings. This is a critical step in closing out a notary commission, as failing to surrender the journal is a violation of the law. Question 19. A jurat requires the signer to A. Acknowledge that they signed the document. B. Sign the document in the presence of the notary and swear or affirm the truthfulness of its contents. C. Present two forms of identification. D. Provide a thumbprint in the notary's journal. Answer: B. Sign the document in the presence of the notary and swear or affirm the truthfulness of its contents. The primary function of a jurat is to certify that the signer personally appeared, signed the document in the notary's presence, and took an oath or affirmation that the statements in the document are true. This act turns the document into a sworn statement, which carries legal weight and potential penalties for perjury if found to be false. The key components distinguishing a jurat are the sworn or affirmed aspect and the requirement that the signing must happen in front of the notary. Think of a jurat as what you see in movies when someone raises their right hand and swears to tell the truth, the whole truth, and nothing but the truth. Question 20. If two credible witnesses are used to identify a signer, and the notary does not personally know the witnesses, each credible witness must A. Sign the notary's journal and present a valid photo ID. B. Take an oath and have their thumbprint taken. C. Be named in the document being notarized. D. Swear that they have known the signer for at least 5 years. Answer: A. Sign the notary's journal and present a valid photo ID. When using two credible witnesses to identify a signer, the notary must follow a strict procedure to ensure a reliable chain of identity. The notary does not personally know these witnesses, so the notary must identify them using one of the state-approved identification documents, such as a driver's license or passport. Both witnesses must then sign the notary's journal and take an oath, swearing to the signer's identity. This process creates a detailed, verifiable record of how the signer's identity was established. Question 21. A California notary public can certify a copy of which of the following documents? A. A marriage certificate. B. A United States passport. C. A power of attorney. D. A university diploma. Answer: C. A power of attorney. California law grants notaries the authority to certify copies of only two types of documents: powers of attorney and, upon written request, entries from their own notarial journal. For a power of attorney, the notary can make a certified copy by comparing it to the original and confirming it is a true and complete replica. For nearly all other documents, including vital records like marriage certificates or official documents like passports, the notary is prohibited from certifying copies because a designated official custodian is responsible for issuing them. Question 22. A notary public's commission number must be included on A. The notary's official seal and on all notarial certificates. B. Only the notary's official seal. C. Only the notarial certificates. D. The notary's business card and journal. Answer: A. The notary's official seal and on all notarial certificates. The notary's commission number is a unique identifier assigned by the Secretary of State and is a crucial part of every official notarial act. California law mandates that this number must appear on the notary's official seal itself, as well as being included in the notarial certificate, the acknowledgement or jurat wording. This dual requirement ensures that the notary who performed the act can be easily and accurately identified, which is essential for the document's legal validity and for public record keeping. Always double-check that your commission number is clear on both the seal impression and the certificate. Question 23. A notary is asked to notarize a document written in a language they cannot read. The notary should A. Refuse to perform the notarization. B. Ask a certified translator to explain the document's contents. C. Proceed with the notarization if the notarial certificate is in English and the notary can communicate with the signer. D. Only proceed if the signer can provide a written translation of the document. Answer: C. Proceed with the notarization if the notarial certificate is in English and the notary can communicate with the signer. A notary does not need to understand the contents of the document being notarized. Their duty is to verify the signer's identity and witness the act of signing. As long as the notary can communicate directly with the signer to administer the oath or take the acknowledgement, and the notarial certificate itself is in a language the notary understands, typically English, the notarization can proceed. For instance, a notary can notarize a document written in Spanish for a Spanish-speaking signer, provided they can directly confirm the signer's identity and understanding of the notarial act without a translator. Question 24. A notary may refuse to provide notarial services to a customer if A. The customer is not a resident of California. B. The notary has a reasonable suspicion that the document is fraudulent. C. The document is for a real estate transaction. D. The customer cannot pay the fee in cash. Answer: B. The notary has a reasonable suspicion that the document is fraudulent. While a notary public is a public servant who should not unreasonably refuse service, they have a duty to prevent fraud. If a notary has a legitimate and reasonable belief that the transaction is illegal, fraudulent, or that the signer is being coerced or does not understand the document, the notary has the right and responsibility to refuse to proceed. For example, if the details in a document seem highly suspicious or the signer appears confused and unable to explain the document's purpose, refusing to notarize is the correct and protective action. A notary's primary duty is to be a gatekeeper against fraud. Question 25. Which of the following statements about a notary's advertising is true? A. A non-attorney notary may use the Spanish phrase, notario publico. B. A notary can advertise that they are an immigration specialist without any other qualifications. C. A non-attorney notary advertising in a foreign language must include a disclaimer that they are not an attorney. D. Advertising notary fees higher than the statutory maximum is permitted if it includes travel costs. Answer: C. A non-attorney notary advertising in a foreign language must include a disclaimer that they are not an attorney. To prevent the unauthorized practice of law, California has strict rules about how notaries can advertise, especially in foreign languages. In many Spanish-speaking countries, a notario publico is a high-level attorney, so using this term in California is illegal for a non-attorney notary. Any non-attorney notary who advertises in a foreign language must post a clear and conspicuous notice, in both that language and in English, stating that the notary is not an attorney and cannot give legal advice. This disclaimer must also include the fees for notarial services.